Have you ever wondered how a person can change their mind about their last wishes, documented in a will? What does the law in the Philippines say about undoing such significant decisions? Today, we're diving deep into a crucial topic for anyone involved in estate planning, particularly law students and bar examinees: the revocation of wills, specifically under Articles 828 to 834 of the new Civil Code of the Philippines. This area of law is frequently tested in the Philippine bar examination, making our discussion today particularly valuable. Understanding the intricacies of how wills can be revoked ensures that legal professionals and students are well prepared not only for academic examinations, but also for practical, real-life applications in legal practice. If you're aiming to excel in the bar or enhance your expertise as a legal professional, you're in the right place. Before we proceed, make sure you subscribe to our channel to stay updated on essential legal topics that can empower your career and academic journey in the field of law.
Revocation of wills under the new Civil Code of the Philippines, Articles 828 to 834. 1. The legal framework for revocation. Under the new Civil Code of the Philippines, specifically Articles 828 to 834, various grounds and procedures are laid out for the revocation of wills. These articles ensure that the testator has the freedom to alter their last will as circumstances or intentions change. Understanding these provisions is crucial for anyone drafting, executing, or contesting a will. 2. Methods of revocation. Express revocation. This occurs when a new will or codicil explicitly states that it revokes the previous will or codicil, wholly or partly. Implied revocation. This takes place through the execution of a subsequent will that does not explicitly revoke the previous will but contains provisions that are wholly or partly inconsistent with it. 3. Destruction of the will. Article 828 provides that a will may also be revoked by the physical act of destruction. This can be done by the testator or by another person in their presence, under their express direction and consent. This destruction can be through burning, tearing, or obliterating the document. 4. Presumptions and burdens of proof. In cases where the original will cannot be found after the death of the testator, and it was last seen in their possession, the presumption arises that the testator destroyed the will with the intention to revoke it. Overcoming this presumption requires compelling evidence to the contrary.
5. Revocation due to changed circumstances. Articles 830 to 834 address specific circumstances under which a will is considered revoked, such as the marriage of the testator after the date of will execution unless it is evident that the will was made in contemplation of the marriage. 6. Re-execution and republication. A revoked will can be revalidated only by re-execution or by republication according to the formalities of law. This area can be complex, and understanding the nuances is vital for anyone involved in estate planning. 7. Legal implications of revocation. The revocation of a will has significant legal implications, including the redistribution of the estate under the rules of intestate succession if no other valid will exists. This can profoundly affect the beneficiaries and their inheritances. We've covered the essential aspects of will revocation under the new Civil Code of the Philippines, but this is just the tip of the iceberg. For a deeper understanding and more detailed case studies, remember to subscribe to our channel. Staying informed on these topics can make a significant difference in your professional and academic legal endeavors.
Frequently asked questions. 1. What if a testator wants to revoke only a part of their will? Partial revocation is permissible under the law, provided it is done with the same formalities as a full revocation or through the execution of a subsequent will or codicil that makes clear the testator's intention to alter only a part of the original will. 2. Can a lost will be revived? A lost or destroyed will cannot be revived merely by finding or reconstructing it. It must be re-executed with all formalities, or a duplicate must be proven to exist and contain the same provisions. Don't forget to subscribe and turn on notifications for more detailed discussions and insights into Philippine law. Whether you're preparing for the bar exam or enhancing your professional knowledge, our content is designed to support your journey in the legal world. Thank you for watching, and see you in our next video.
Situational legal problem. Pedro, a wealthy business owner, had executed a will in 2021, bequeathing all his properties to his only daughter, Maria. In 2023, Pedro married Rosa, a longtime friend. Following the marriage, he decided to change his will to include Rosa, ensuring she would inherit half of his estate. However, instead of drafting a new will, Pedro destroyed the original will by burning it, believing this act would automatically transfer half of his estate to Rosa upon his death, based on his verbal declarations to her. Pedro passed away later that year. Rosa now claims half of the estate as per Pedro's wishes. Question: does Rosa have a legal claim to half of Pedro's estate based on the destruction of the original will and Pedro's verbal declarations? Answer: under Article 828 of the New Civil Code of the Philippines, the physical act of destroying a will indicates an intention to revoke it, assuming Pedro intended such revocation when he burned the will. However, for Rosa to have a valid claim to the estate, a new will conforming to the formal requirements of law should have been executed, including Pedro's intent in a written format. Since Pedro did not execute a new will after destroying the original, and since verbal declarations do not meet the formal requirements for a valid will under Articles 805 and 806 of the New Civil Code, Rosa does not have a legal claim based solely on Pedro's verbal declarations. Without a new valid will, the estate would be subject to the rules of intestate succession. Given that Pedro and Rosa were legally married at the time of his death, Rosa is entitled to her legal share as a surviving spouse under the intestate succession laws, but not necessarily half of the estate, unless such share is validated by a properly executed new will or the intestate share coincidentally amounts to that. Thus, the destruction of the original will without a subsequent properly executed will does not support Rosa's claim to half of the estate based merely on verbal intentions expressed by Pedro. Rosa's entitlement would need to be evaluated under the laws of intestate succession, considering the absence of a valid will at the time of Pedro's death. Here are 3 bar exam questions related to the revocation of wills as per Arts. 828 to 834 of the New Civil Code. 1. Question: 1996, Vanessa died on April 14, 1980, leaving behind a holographic will which is entirely written, dated, and signed in her own handwriting. However, it contains insertions and cancellations which are not authenticated by her signature. For this reason, the probate of Vanessa's will was opposed by her relatives, who stood to inherit by her intestacy. May Vanessa's holographic will be probated? Explain. Suggested answer: yes, the will as originally written may be probated. The insertions and alterations were void since they were not authenticated by the full signature of Vanessa, under Art. 814, NCC. The original will, however, remains valid because a holographic will is not invalidated by the unauthenticated insertions or alterations.
2. Question: 2003, Mr. Ray has executed a will completely valid as to form. A week later, however, he executed another will which expressly revoked his first will, which he tore his first will to pieces. Upon the death of Mr. Reyes, his second will was presented for probate by his heirs, but it was denied probate due to formal defects. Assuming that a copy of the first will is available, may it now be admitted to probate and given effect? Why? Suggested answer: yes, the first will may be admitted to probate and given effect. When the testator tore the first will, he was under the mistaken belief that the second will was perfectly valid, and he would not have destroyed the first will had he known that the second will is not valid. The revocation by destruction, therefore, is dependent on the validity of the second will. Since it turned out that the second will was invalid, the tearing of the first will did not produce the effect of revocation. 3. Question: 1996. If the cancellation of Rosa's name in the will was done by the testator himself, such cancellation shall not be effective and the will in its original tenor shall remain valid. The effectively of the holographic will cannot be left to the mercy of unscrupulous third parties. The writing of Gregorio's name as sole heir was ineffective, even though written by the testator himself, because such is an alteration that requires authentication by the full signature of the testator to be valid and effective. Explain. Suggested answer: if the cancellation of Rosa's name was done by the testator himself, and not authenticated, it invalidates the modification. Therefore, the holographic will in its original form remains valid unless changes are properly authenticated. This ensures the will's effectiveness cannot be compromised by unauthorized alterations. These examples provide an insight into how Philippine law handles various issues